Welcome all. In this session, we will discuss about the industrial dispute. Industrial relations are invariably a combination of cooperation, collaboration, and conflict between labor and management. However, efforts should be made to seek the maximum degree of cooperation and collaboration between them so that organizational objectives may be achieved efficiently. Some degree of conflicts always remain because of following different reasons, like both labor as well as management have different orientations and perception which generate generally negative image about each other. Both the groups claim completely rationality for their demands because there are no mutually accepted norms to guide their behavior in the pursuit of their objective. But the group don't come on the negotiation table with a clean slate. They bring with them some carry over effects from the past, which signifies the existence of conflict between the labor and the management. Conflict is one of the feature of industrial relation is a general concept, but when it acquires a concrete and specific manifestation, it becomes an industrial dispute. Industrial conflict is general, whereas industrial dispute is specific. Going still deeper, the term industrial dispute is used in the literature, including government publications, to denote work stoppages as well as those differences between labor and management that are settled through the individual industrial relations machineries. The term industrial dispute is defined by Section 2K of Industrial Dispute Act 1947 as any dispute or differences between employers or between employers and workmen or between workmen and workmen connected with the employment or non-employment or the terms of employment or with the condition of labor of any person. This definition is very wide and covers all possible contingencies that may result in work stoppages or strikes. In a strict judicial sense, it would not exclude it strikes in support of workers in other industry or for that matter in some other country. Industrial dispute is disagreement and difference between two disputants, namely labor and management. This disagreement or difference could be on any matter concerning them individually or collectively, but must be connected with employment or non employment or with the condition of labor. The definition of industrial dispute as per Section 2K of the Industrial Dispute Act 1947, given in the para above, could be divided into four parts. One is a factum of dispute. Factum of disputes denote the fact of existence of dispute, that the dispute or differences or disagreement must be something fairly definite and of real substance, not a mere personal quarrel, and should not be existing only in the mind of parties. Further, the term connotes a real and substantial difference having some element of persistency and likely to endanger the industrial peace of community if not resolved. Second is a parties to dispute. Parties to dispute identify the different parties like employers and workmen and workmen. To an ordinary person, the parties to industrial disputes includes employers and workmen, as most of the industrial disputes are of this category. The use of plural number for the disputant parties in the definition raises doubt whether there can be an industrial dispute between an employer and an individual workman. This doubt is, however, removed by Section 2A, which was added to the Act by an amendment in 1965. The section consider an individual dispute as an industrial dispute if it relates to discharge, dismissal, retrenchment, or termination of a worker's services. Thirdly, the subject matter of industrial dispute must be specific, which affect the relationship of employers and workers, the term of employment and conditions of labor, and are included under the term industrial dispute. And uh, lastly, the adjective industrial relates the dispute to an industry as are defined in section 2J of Industrial Dispute Act. Now, causes of industrial disputes. The dispute between the management and the workers may arises on account of different factors like economic causes, political causes, personal causes, indiscipline, etc. I can categorize these causes of disputes in four terms like industrial factors. Under this category, some of the causes of disputes may be an industrial matter relating to the employment, demand for higher gratuity and other retirement benefits, demand for higher bonus, demand for paid holidays, reduction of working hours, better working conditions, etc. Because the dispute arising out of unemployment, inflation, change in the attitude of employers, and rivalry among unions. Another cause is a management attitude towards worker. Sometimes management is very unwilling to talk over any dispute with their employees. Management sometimes unwilling to recognize a particular trade union, delegating enough authorities to representatives. It is sometimes unwilling to negotiate and settlement of disputes. So the insistence to take care of recruitment and promotion without consulting the concerned employees, industrial disputes may arise. Another cause of industrial dispute is a government machinery. Though there are number of enactment for promotion of harmonious relations, it is an ineffective, unsatisfactory due to various reasons like their irrelevance in the context of the challenges. So the government conciliations machineries has settled a very negligible number of disputes. Another causes are like other causes means the political causes. Trade unions in India are controlled by various political parties. In many cases, their leadership vests in the hands of persons who are more interested in achieving their political interests rather than the interest of laborers. Sometimes industrial dispute arise because of a personal problems like dismissal or layoff, transfer or promotion, etc. And industrial dispute also takes place because of indiscipline and violence on the part of the workforce. Lockouts are resorted to by the management to curb indiscipline and violence. Now, impact of industrialization, industrial disputes. Consequences of industrial disputes are often far reaching as they disturb the economic, social, and political life of a country. Industrial disputes create turmoil between the management and the labor and are in fact symptoms of poor industrial relations. An organization being in the grip of tense industrial relations find it impossible to introduce any innovation or effects any productivity improvement exclusively through the various industrial engineering techniques. So, the poor industrial relation within an organization are not only harmful for it but are also against the interest of the society as a whole. The adverse effect of industrial conflict may be enumerated like disturbance of industrial peace or resistance to change, frustration, it increasing the frustration among employees, it also intensification of social tensions, it also affect the overall economy. So industrial disputes are harmful, undesirable, and even dangerous. They create unrest in the industry and create tension among the employers and employee. So such disputes are particularly undesirable in developing countries. The outcome of industrial disputes can be divided in two categories, that is strike and lockout. Whenever industrial dispute arise, workers generally resort to one or more of the following weapon: strike, boycott, picketing, gherao. So first of all, we will discuss about the what is strike. When workers collectively cease to work in an industry, it is known as a strike. It means a cessation of work by a body of persons employed in an industry acting in combination or a concerted refusal of any number of persons who are or have been so employed to continue to work or to accept employment or a refusal under a common understanding of any number of such persons to continue to work or to accept employment. For trade unions, the strike is most powerful weapon for forcing the management to accept their demands. There are various types of strikes are exist like economic strike, sympathetic strike, general strikes, strain strike, slowdown strike, boycott, picketing, ghirao. There are so many types of strike which can be used by the workers for pressurize the management or for changing their decisions. Like strike is also categorized in three forms: primary, secondary, and other. Like ghirao. Ghirao in Hindi meanings to surround. Workers may ghirao the members of management by blocking their exit and forcing them to stay inside their cabins just like prisoners. The main object of ghirao is to inflict physical and mental torture to the person who ghiraoed, and hence the weapon disturb the industrial peace to a great extent. It has have been criticized on both legal and moral ground. Legally, ghirao amount to imposing wrongful restraints on the freedom of some persons to move. That is why court have held it is an illegal action. Like picketing, the when workers are discussed from work for stationing certain men at the factory gate, such as a step in knowing as a picketing. If picketing does not involve any violence, it is perfectly legal. Picketing is an act of posting pickets and implies marching or patrolling of the workmen in front of the premises of the employer, carrying and displaying signs, banners, placards for the purpose of preventing others from the entering the place. And boycott, the workers may decide to boycott the company by not using its product, such as an appeal may also be made to the public in general. In the form case, the boycott is known as a primary, and in the latter secondary, it is a coercive method whereby the management is forced to accept their demands, since the boycott affect the marketability of its product. There is also a pan down strike. Employees remain on their jobs under this type of strike. They do not stop work but restrict the rate of output in an organized manner, or they keep control over the production facilities. Token strike also, lightning strike, economic strike. Most of the strikes of workers are for more facilitates and increase in wage levels. In economic strike, the laborers demand increases in the wages, traveling allowances, house rent allowances, dear net allowances. When workers one of units or factory go on strike in sympathy with workers or another unit of factory who are already on strike, it is also called as a sympathetic strike. uh, Sympathetic strike. The workers of sugar industry may go on strike in sympathy with their fellow workers of the textile industry who may already be on strike. It general strike also, it means a strike by members of all or most of the unions in a region or an industry. It may be a strike of all the workers in a particular region of industry. So these are the outcomes of industrial disputes. But and lockout, the employers may form their associations which may collectively oppose the working class and put pressures on the trade union as a form of employers association. An employer may close down the place of unemployment temporarily, such a step in technically known as a lockout. It is reverse of a strike, and it is very powerful weapon in the hand of an employer to coerce or pressurizes the workers to return to the place of work. According to the Industrial Dispute Act 1947, lockout means the closing of a place of employment or the superpension of worker and the refusal by an employer to continue to employ any number of persons employed by them. Now, machineries for handling disputes. It categorized in two forms: preventive machineries and settlement machineries. Lasting industrial peace requires that the cause of industrial disputes should be eliminated. So preventive steps should be taken so that industrial dispute do not occur. But if preventive machinery fails, then the industrial dispute settlement machinery should be activated by the government, because non-settlement of disputes will prove to be very costly to the workers, management and the society as a whole. So the machineries for handling of industrial disputes has been um, as a preventive machinery and settlement machineries. The preventive machineries has been set up with a view to creating harmonious relations between labor and management so that dispute do not arise. It comprises of the following measures, like first is a workers participation in management. It is a method whereby the workers are allowed to be consulted and to have a say in the management of the unit. The important scheme of workers' participations are work committees and joint management councils or shop councils and joint councils. They has been discussed in this industrial disputes. So the concept of workers participation in management encompasses, it provide a scope for employees in decision making of the organization. The participation may be at the shop level, departmental level or the top level. The participation includes the willingness to share the responsibilities of the organization by the workers. The main objective of workers participation in management is to establish a industrial democracy. It also very helpful to build the most dynamic human resource at workplace, and it is very helpful in raising the level of satisfaction in workers as a social and esteemed with satisfy our social and esteem needs. And it also to strengthen labor management cooperation and maintain industrial peace and harmony at workplace. The objective of workers' participation in management is to increase the productivity for the advantages of the organization and workers at the society at large, and it also psychologically objective to secure full recognition of the workers. Collective bargaining is the another, it is an another preventive machinery. According to Dale Yoder, collective bargaining is the term used to describe a situation in which essential conditions of employment are determined by a bargaining process undertaken by representatives of a group of workers on the one hand and one or more employers on the other. So, collective bargaining not only includes negotiation, administration, and enforcement of the written contract between the employees and the employers, but also includes the process of resolving labor management conflicts. The role of collective bargaining in the solving issues arising between the management and workers at the plant or industry level has been widely recognized. Labor legislation and the machinery for its implementation prepare a framework according to which industrial establishment should operate. But whatever labor laws may be laid down, it is approach of employers and trade union leaders which matters. Unless both are enlightened and industrial harmony is not possible, therefore, the solution to common problem can be found directly through negotiation between both parties, and in this context, the scope of collective bargaining is very wide. Another preventive machinery is a grievance procedure. Grievances are symptoms of conflict in the enterprise, so they should be handled very promptly and efficiently. Coping with grievances forms an important part of a manager's job. The manner in which he deals with grievances determines his efficiency in dealing with the subordinates. A manager is successful if he is able to build a team of satisfied workers while removing their grievances. This would help in the prevention of industrial dispute in the organization. Another preventive machinery is the tripartite bodies or bipartite bodies. Industrial relations in India have been shaped largely by principles and policies evolved through tripartite consultative machinery at industry and national level. The aim of the consultative machinery is to bring the parties together for mutual settlement of differences in a spirit of cooperation and goodwill. Another preventive machinery is a code of discipline. It is a set of self-employed, mutually agreed voluntary principle of discipline and good relations between the management and the workers in industry. In India, code of discipline was approved by the 16th Indian Labour Conference held in 1958. It contains three sets of code which have been discussed later. According to National Commission on Labour, the code in reality has been limited use. When it was started, very favorable hopes were thought of it, but soon it started acquiring rust. Main reason for the lapses on the part of the employers and employees to secure harmonious relationships, the code of discipline maybe there was absence of self imposed voluntary restraints on the part of the parties, the rivalry among labor representatives or conflict between the code and the law, the state of indiscipline in the body politic, that is the whole set up is charged with indiscipline and the code should not work, and sometimes the employers could not implement the code in many respects for reason beyond their control. The term and condition of employment have been a bone of contentions between labor and management since the advent of factory system. To prevent the emergence of industrial strife over the condition of employment, one important measure is the standing order. Under the Industrial Employment Standing Order Act 1946, it was made obligatory that standing order would govern the condition of employment. The standing order regulate the condition of employment from the stage of entry to the organization to the stage of exit from the organization. Thus, they constitute the regulatory pattern for industrial relation. Since the standing orders provide do and don'ts, they also act as a code of conduct for employees and during their working life within the organization. The standing orders define with sufficient precision the condition of employment under the employers and hold them liable to make the said conditions known to workmen employed by them. These orders regulate the condition of employment, discharge, grievances, misconduct, disciplinary actions, etc. of the workmen employed in industrial undertaking. These issues are potential problems in industrial relations. Unresolved grievances can become industrial dispute and disciplinary actions in the wake of disciplinary proceedings against misconduct may also lead to industrial dispute. This another machinery is a settlement machinery. This machinery has been provided under the Industrial Dispute Act 1947. It in fact provides a legalistic way of settling the dispute. As the goal of preventive machinery is to create an environment where the dispute do not arise at all. Even then, if any differences arise, the judicial machinery has been provided to settle them, lest they should result into work stoppage. In this sense, the nature of this machinery is curative, for it aims at curing the ailments. So the machinery compromises different organs like conciliation, court of inquiry, voluntary arbitrations, educations, etc. Now, first of all, we discuss about the conciliation. Conciliation is a method of resolving the industrial conflict with the help of third party who intervenes in the dispute situation upon a request by either or both the parties. It is a procedure in which the decision making function remain the prerogative of the parties to the dispute as in collective bargaining. So the conciliator simply assists them in their negotiations and decision making. He resolves the impasse and remove the bottlenecks. So conciliation is a form of mediation Mediation is the act of making active efforts to bring two conflicting parties to compromise. Mediation differs from conciliation in that where conciliators play only a passive and indirect role, and the scope of his function is provided under the law, and mediator takes active part, and the scope of his activities are not subject to any statutory provision. Conciliation is the practice by which the service of a neutral party are used in a dispute as a means of helping the disputing parties to reduce the extent of their differences and to arrive at an amicable settlement or agreed solution. The Industrial Dispute Act 1947 provide for conciliation and can be utilized either by appointing conciliation officer or by constituting a board of conciliation. This conciliation machinery can take a note of a dispute or apprehend dispute either on its own or when approached by either party. Under the Act, conciliation is compulsory in all disputes in public utility services and optional in other industrial establishments. Over the year, the optional provision appears to be acquiring compulsory status in non-public utilities also. Now, conciliation officer. The law provides for the appointment of conciliation officer by the government to conciliate between the parties to the industrial dispute. The conciliation officer is given the power of a civil court, whereby he is authorized to call and witness the parties on oath. It should be remembered, wherever civil court cannot go beyond interpreting the law, the conciliation officer can go behind the facts and make judgment which will be binding upon the parties. In case of conciliation officer fails to resolve the difference between parties, the government has the discretion to appoint a board of conciliation. The board is tripartite and ad hoc body. It consists of a chairman and 2 or 4 other members. The chairman is to be an independent person and other members are nominated in equal numbers by the parties to the dispute. Conciliation proceedings before a board are similar to those that takes place before the conciliation officer. The government has yet another option of referring the dispute to the court of inquiry instead of the board of conciliation. The machinery of the board is set in motion when a dispute is referred to it. The board does not hold the conciliation proceedings of its own accord on the disputes being referred to the board. It is the duty of the board to do all things as it thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement. So the board must submit its report to the government within 2 months of the date on which the dispute was referred to it. This period can be further extended by the government by 2 months. Another settlement machinery is a court of inquiry. In case of the failure of conciliation proceeding to settle a dispute, the government can appoint a court of inquiry to inquire into any matter connected with or relevant to industrial dispute. The court is expected to submit its report within 6 months. The court of inquiry may consist of one or more persons to be decided by the appropriate government. The court of inquiry is required to submit its report within a period of 6 months from the commencement of inquiry. This report is subsequently published by the government within 30 days of its receipt. Unlike during the period of conciliation, workers' right to strike, employers' right to lockout, and employers' right to dismiss workmen, etc., remain unaffected during the proceeding in a court of inquiry. It is different from a board of conciliation. The former aim at inquiring into and revealing the cause of an industrial dispute. On the other hand, the latter basic objective is to promote the settlement of the industrial dispute. So, a court of inquiry is primarily a fact-finding machinery. On failure of conciliation proceeding, the conciliation officer may persuade the parties to refer the dispute to a voluntary arbitrator. Voluntary arbitration refers to getting the dispute settled through an independent person chosen by the parties involved mutually and voluntarily. Arbitration offers an opportunity for a solution of the dispute through an arbitrator jointly appointed by the parties. This process of arbitration saves time and money of both the parties, which is usually wasted in case of adjudication. So voluntary arbitration become popular as a method of settling differences between workers and management with the advocacy of Mahatma Gandhi, who had applied it very successfully in the textile industry of Ahmedabad. Another settlement machinery is education. The ultimately remedy for the settlement of industrial dispute is its reference to education by labor court or tribunals. When conciliation machineries fails to bring about a settlement, education consists of settling disputes through intervention by the third party appointed by the government. The law provides the education to be conducted by the labor court, industrial tribunal or national tribunal. A dispute can be referred to education if both the employer and the recognized union agree to do so. A dispute can also be referred to education by the government even if there is no consent of the parties, in which case it is called compulsory education. The dispute can be referred of three types of tribunals depending on the nature and facts of disputes in questions like labor court, industrial tribunal and national tribunal. The procedures, powers, provisions regarding commencement of award and period of operation of award, these three bodies are similar. The first two bodies can be set up either by state or central government, but the national tribunal can be constituted by the central government only. When it thinks that the adjudication of a dispute is of national importance, these three bodies are not hierarchical in nature. It is the government's prerogative to refer a dispute to any of these bodies depending on the nature of dispute. Thus, the appropriate governments plays a direct role in regulating the industrial relations through education. It is only when the appropriate government is of the opinion that an industrial dispute exists or is apprehended that it may, by an order in writing at any time, refer the dispute for education, and then only the educating authority acquires the jurisdictions to deal with the dispute to referred. There are two situations when it is obligatory for the appropriate government to make a reference to education. First, when both parties to a dispute apply in the prescribed manner, either jointly or separately, for a reference, the appropriate government has to refer the dispute to education provided it is satisfied that the persons applying represent the majority of each party. And second situation is when the dispute relates to a public utility service and notice of a strike or lockout according to law has been given. The appropriate government has to make a reference to education. However, if the appropriate government considers that the notice of a strike or lockout is frivolously given or it is inexpedient to make a reference, so no such reference may be made. The opinion of the appropriate government is very material here. Another settlement machinery is a consultative machinery. They operate at plant, industry, state or national level. At plant level, there are work committees and joint management councils. Being bipartite in character, work committees are constituted as per the provision of Industrial Disputes Act. Labor advisory boards operate at the state and the all India level, and there are Indian labor conferences and standing labor committees. So the bodies operating at state and national level and tripartites in character representing government and labor and management. Thank you.